Our gracious lady by the name Radhika Aurora, who is with us. So we request that she be added to our team, my lords and my ladies. Okay. So with your permission, my lords, my ladies, if I can start the submissions on behalf of the Honorable the Attorney General.
Yes, you may.
My Lord, my ladies and my lords, I'm sorry to interrupt the Solicitor General. We have a small application to make which will not take more than 2 minutes because it's a straightforward housekeeping issue. And we got served last night.
What is it, Senior Professor Kendiki?
I'll allow Mr. Mutuma to address the court for 3 minutes or less.
Thank you, Your Lordship and my ladies. We want to make an application in respect to 2 affidavits that we would like them to be struck out of the record. Now, via our notice of motion dated 8th of June 2021, we filed an application under Rule 29 of the Court of Appeal Rules, seeking to adduce further evidence in form of the JLAC report. That application was allowed on 25th of June 2021, and the court, in its ruling, indicated that any party who wishes to respond to our affidavit to do so by close of business yesterday. We have received 2 affidavits, one by IBC, sworn by Michael Goa, and another one by BBI Secretariat, sworn by Dennis Waweru on 27th of June 2021.
Yes.
Now, the said affidavits seemingly are in response to our affidavit adducing the JLAC report, but a close look at the said affidavit speaks otherwise. I will begin with the affidavit by IBC, where IBC seeks to introduce new evidence that has nothing to do with the JLAC report. What they're seeking to adduce is a Gazette notice dated 16th September 2020, confirming that there has been an ongoing voter registration. Now, this is an issue that was brought up at the High Court. IBC did not respond to that issue by adducing that Gazette notice. I note the Gazette notice is dated 16th of September 2020, so there was nothing that prevented them from adducing that piece of evidence at the High Court. It would then appear that they are trying to cure defects in their response at the High Court by sneaking in this piece of evidence at this juncture. My view is that they ought to have sought leave, just like the way we did, to adduce that Gazette notice.
When was that affidavit filed?
That affidavit was filed yesterday, my lord, and it's dated 28th of June.
Did it comply with the times?
Yes, it complied with the timelines that the court had issued in respect to the response to affidavits, but our contention is that it does not respond to the JLAC report. It seeks to sneak in evidence that was not availed at the High Court. So in that respect, I'll be asking the court to expunge or strike out paragraph 5 and 6 of that affidavit, together with the Gazette notice that has been annexed thereof.
Not the entire affidavit, just paragraphs 5, 6 and the Gazette notice?
Correct, my lord.
I'm not sure whether we have even seen the affidavit.
Perhaps the court can take time, and it is dated 28th of June 2021. I believe it was filed yesterday by IBC. it is important for the court to look at those specific paragraphs before making a ruling on the same.
That's all?
Yes, in respect to the other affidavit sold by Dennis Waweru, it is a one-paragraph affidavit. It seeks to introduce a JLAC report on the referendum bill of 2020. Now, this is a bill that is distinct and separate from the BBI Constitutional Amendment Bill. It would then appear that this part of bill is being introduced to cover gaps in respect of the lack of legal framework in the processing of a constitutional amendment bill by way of a popular initiative. Again, it does not even seek to respond to the affidavit of Merodo Waweru on the JLAC report. It is just a new piece of evidence that is being introduced at this juncture. Again, it does not comply with Rule 29 of the Court of Appeal rules. It is purely being brought again to improve their case. I note that the referendum bill that is being sought to be introduced, rather the report, is dated October 2020. Again, there was no reason as to why the BBI team could not have adduced this piece of evidence at the High Court. This, in our view, my lords and my ladies, amounts to trial by ambush, and it's a way of sneaking in evidence at the Court of Appeal and procedurally. That's all, my lord and my ladies. Thank you.
So can IEBC and BBI Secretariat just respond quickly?
If it may please, my lords, my ladies, the response is really very simple. First of all, the responses were filed within time. Secondly, to the extent that the applicant on this issue sought and was allowed to adduce new evidence, it is not in their province to determine how the respondent should respond to that new evidence. The question of relevance is for the respondent to that issue, not for them as the applicant. More importantly, my lords, as indicated, they sought to introduce a report that was not before the trial court, the Justice and Legal Affairs Committee report. And as demonstrated, they did not produce the complete report. That report refers to an annexure, which is an additional report of the JLAC committee dealing with the referendum bill. That is the only report that is now produced in response to complete the new evidence that they have brought before this court. They cannot say it could have been produced before the High Court because they had not produced the JLAC report in order to complete it. Most obliged, my lords.
My lords and my ladies, on behalf of the IBC, first we want to associate ourselves with...
Sorry, this is for record purposes, Mr.
My name is Gumbo Eric.
Okay. Yes.
So my lords and my ladies, first I would want to associate myself with submissions from learned senior counsel Mr. Otiende. Secondly, I would want to point out that the issue of the annexure that is in our affidavit first is a gazette notice, which ordinarily would be a public document. Two, that in addition to that, The JLAC report that was filed with the leave of the court, and we did mention this in our replying affidavit, introduced a number of new issues. We didn't want to come and make that application again, that we respond to those new issues, which then would have had the effect of delaying these proceedings. The singular issue that that Gazette notice responds to is just a confirmation of the fact that there's been indeed continuous registration of voters and nothing more. My lords and my ladies, if you look at the JLAC report itself and the Hansard that is with it, the deliberations that have been presented before you are of such a broad nature as to cover each and every aspect of the petition that is before you. In the event that we don't have that evidence or that Gazette notice for purposes of responding to those issues, my lords and my ladies, we shall stand prejudiced. It is not introducing anything new. The question of continuous registration of voters has been before you. There's nothing new that has been introduced. That will be all, my lords and ladies.
Sorry, Council, can you connect the issue of the JLAC report and the continuous registration of voters? Let's get that connection clearly.
Yes, my lord. So what I indicated is that other than the JLAC report itself, we also had the Hansard, which was part of the documents that were introduced with the leave of this court. The deliberations that went on, both which are contained in the JLAC report, as well as in the deliberations, are such as to cover every single spectrum that this petition is dealing with. So, to that extent, if we do not get an opportunity to respond to some of those deliberations, which would be available to the respondents for purposes of the proceedings that will be before you, then we'll stand prejudiced because we'll not have had an opportunity. And I said, my lords and my ladies, in our replying affidavit, we did mention that that was the risk that that leave was going to then place us in, because it was going to introduce issues which we thought we would not have had an opportunity to deal with. One of them is that question of registration of voters, because it is an issue that also was touched on if you look at the Hansard that was that supported the report.
Okay.
I'm most obliged.
In a brief rejoinder, my lord,
I would request, for purposes of recording, whenever counsel you stand there, just say your name, even if it is for the 10th time, because the transcription needs to record that.
Much obliged, my lord. My name is Elias Mutuma, for the 19th, 20th, and 21st respondents in Appeal 291. In a brief rejoinder, my lord, in respect to my learned senior counsel Otiende Amolo, the affidavit does not in any way state that they are seeking to introduce an annexure to the report that we had sought and was granted leave to adduce. In fact, the title of that document in itself does not even say that it is a replying affidavit. The title is that it is the appellant's further affidavit. If indeed that referendum bill was part of the JLAC report, there was nothing that would have been simple than for them to state exactly that. We confirm that we filed a full report as received from Parliament, and the same is complete. As to the issue raised by the IBC, the court in its ruling was very clear, granting us leave, that the respondents were only supposed to respond to issues related to the production of the documents stated in our application, that is the JLAC report. Now, the Gazette notice that is sought to be introduced has nothing to do with the JLAC report. It was not an issue that was discussed by Parliament. It is not captured in the JLAC report. We do not even intend to address the issue of voter registration through the JLAC report. What is important, my lord and my ladies, is that the issue of voter registration was one of the issues that was active in the High Court. It is an issue that the High Court made a determination on. It was part of the pleadings by the petitioners. IBC had that opportunity to respond to that issue at the High Court, because again, the Gazette notice being sought to be introduced is not a new Gazette notice. It is dated 16th of September 2020. Now, these petitions were filed in December last year, so this Gazette notice was in existence before those petitions were filed. They ought to have introduced that piece of evidence at that time. That's all, my lord. Thank you.
My Lord the Mayor, on behalf of the 76th respondent.
To respond to the same.
Yes, my Lord, and the reason I've been constrained to get on my feet.
This is Mr. for record, Mr. Mutomi.
My name is Mutomi Nkolu, my Lord. And on behalf of the 76th respondent, who is Moraro Moke. My Lord, I would not ordinarily have stood, but the reason I'm constrained to come here is because this issue of voter registration was raised in the petition that Mr. Moraro Moke filed at the High Court. As you make your decision on whether the IBC should be allowed to introduce a Gazette notice showing that there has been continuous registration all along, my Lord, I will invite you to look at paragraph 769 of the judgment of the High Court. And the reason this is important, my Lord, in the High Court, the official position of the IBC, according to that paragraph of the judgment, was that the last time the continuous voter registration was done was just before the by-election for Kibra constituency in the year 2018, about 3 years ago, my Lord. And now they are coming before you, having told the High Court that, to tell you actually We have been doing voter registration all along, and we have a Gazette notice to show it. A Gazette notice that was in existence at a time when they told the High Court a very different position. My Lord, we are asking you to note that. It's on the record. And for that reason, we will very humbly urge the Honorable Court to strike out that Gazette notice. They are trying to close the stable long after the horse has bolted. Thank you, my Lord.
Now, the view of the court is that we want to give a short ruling at 11:30 when we return from our tea break. I do not know whether the issue relating to that affidavit and the Gazette notice is one that is going to feature in Mr. Ogeto's address of the appeal. I don't think it is. It will come later. And if the issue will come later, we would then want to rule on it after we adjourn at 11.
Lords, to be of assistance to the court, this is not a matter that is featuring in our submissions, and we can proceed as proposed by your lordships and your lordships.
So just 1 minute. So I have briefly recorded that we shall make a ruling on the question of striking out the two affidavits as raised by counsel at 11:30 when we resume after tea break. So you may continue, Mr. Ogeto.
With the kind indulgence of the court, my name is Kanjama Advocate, and I request to address the court before my colleague proceeds.
Mr. Kanjama, what's the issue? Mr. Ogeto, just take a brief, take a seat briefly.
Lord, I also seek to address the court on a separate issue.
Your microphone is not on.
My name is Charles Kanjama. I also seek to address the court on a separate preliminary issue, and I will be brief. My Lord, there have been three decisions of benches of this court on the question of who can participate in these proceedings. The first was issued on 2nd of June 2021, in which, in order number 2, all parties who had filed notices of appeal or intended appellants were given access to these proceedings, and this order was issued after I addressed the bench that was sitting on that date. My Lord, there was a ruling issued by a different bench yesterday, 28th of June, which allowed two amici who are not present in the proceedings in the High Court to also participate in these proceedings. And both of those rulings were facilitative of persons who intended to participate in the appeal. And there was a third ruling also issued yesterday, which restricted participation by myself in these proceedings and struck out a memorandum of appeal that had been filed by myself on the basis of 2 applications, one by IEBC and one by the Attorney General. The application by IEBC was never served upon myself, and the submissions that I prepared in response to the application by the Attorney General, I say seem with hesitation, seem not to have been considered by the court. Therefore, my lords, my ladies, I did file an application dated 28th of June seeking a second look by the court at the order that was issued yesterday. My lords, I note, my ladies, I note that my firm and myself have already been put on record in Appeal E291, which is the appeal that is proceeding, and pursuant to directions given by the Deputy Registrar, after the orders of this court of 2nd of June, we were requested to file a distinct appeal as an intended appellant, which is appeal number E307. And so there is a question that needs to be clarified as the court begins the hearing in regard to whether that appeal E307 shall be canvassed together with the other consolidated appeals. My lords, my ladies, when there is a momentous substantive appeal such as this one, the court also has a great opportunity to make momentous determinations on procedural matters that can clarify certain questions of procedure and law that the court has previously taken divergent views from time to time. And so we are urging the court to allow us to give a decision on this application and to allow us to submit on it. There are 3 issues that would be requesting the court to consider. One is the question of locus and right.
No, don't argue now.
Yes, I'm not arguing. I'm just mentioning the 3 issues, my lord, kindly. One is the question of, if that's okay.
Mr. Kanjama?
Yes.
The president says, don't go into what your application is about until the court decides whether or not we will hear you. Perhaps it may be nice to respect that.
Precisely. And Mr. Kanjama, the bench, the presiding judge of the bench that heard your application yesterday, the Honorable Lady Justice Okwengu, may have something to say regarding that application.
Most obliged. I'm sorry for having appeared to have disrespected the court. It was not my intention. I'm very sorry.
It's fine, Mr. Kanjama.
Thank you, Presiding Judge. Mr. Kanjama, upon receiving your request for review, we have checked and we do have communication from IEBC indicating that they served you with their application. We also have the replying affidavit which you have responded to, that you filed in response to the application by the AG. The application by the AG and the application by IEBC were in substance similar application. They were all seeking to have your notice of appeal struck out, and you denied the opportunity of appearing in this matter. So we believe that you are served because we have that indication from IEBC. We also believe that even if we are to accept what you are telling us now, that you are not served, and we are to review that order to the extent of setting aside the part that relates to the application of IEBC, I don't think it would change matters much, because there is already an order that is barring you, or rather not barring you, but restricting you from participating in this appeal. And that order, insofar as the Attorney General is concerned, you are not challenging it. So I think that what you are telling us now is really more of an academic exercise. It will not change the situation. Thank you.
So Mr. Kanjama, you have heard the view of the bench to which you have sought a review of yesterday's ruling. So we want to proceed with this appeal.
My Lord, could I very kindly just address the court on, for 1 minute on the procedural issue that is before you. I was just saying that yes, I have heard and I've respectfully listened to the directions that have been given. I however plead with the court, since I'm now before a 7-judge bench, to at least allow the applicant to articulate his application, because the application is not seeking to appeal against the decision of the High Court issued in March.
All right, Mr. Kanjama, since we are going to make a brief ruling on the other issue at 11:30,
yes,
we will also address your concern. So that will be at 11:30.
Could I request to address the court before it makes a ruling on my application? But I'll be guided.
No, Mr. Kanjama, there is an application in writing, and we know what you have said in your request for review. And so we will look at that supplemented by what we have so far heard from you. So I request that you take a seat and let Mr. Ogeto proceed. Kindly.
Most obliged.
My Lord. With your permission, my Lord, this is Professor Migaya Kech, amicus. With the permission of the court, kindly allow me to confirm that I filed and served my brief pursuant to the orders of the court issued yesterday. I also confirm that I'm at the disposal of the court. Thank you, my lords, my ladies.
My lords, just very briefly, Elisha Ongoya here. I don't know whether my microphone is on. Thank you. Just very briefly, so that you give a direction to get out at 11:30. There is a direction in the ruling regarding admission of Professor Migaya Kech.
I don't know whether your microphone is on. We can't hear you.
I trust I can now be heard. Thank you. My name is Elisha Ongoya. I represent the 74th and 75th respondents. And I address you regarding the...
Mr. Ongoya, perhaps you could give us the name of your client instead of just the number of the respondents.
Let me just pick...
You have to confirm from the record who your client is?
I'm leading counsel on record, my lords. I'm leading Mr. Ogada. My name is, I appear for just as Juma and Isaac Ogola, leading Mr. Ogada in the matter.
That is, I will say Ogola
and Juma.
Yes.
Thank you. So, very briefly, regarding the joinder or the admission of two amici, Professor Migaya Kech and Professor Charles Fombad, the respondents were directed to serve any submissions to their submissions within 24 hours from service. We've just been served this morning on our way to this court at 8:03 in the morning and 8:13 in the morning. It's therefore practically not possible to respond within 24 hours, since we will be here up to late this evening. I was requesting if we could be given up to the last hearing date of these proceedings, so that we have a practical opportunity to prepare and respond. to those submissions. That's all.
Mr. Alicia Ngoya, when urgent matters come before court, they must be dealt with expeditiously.
Correct.
And therefore, you will have to burn the midnight oil. You are a team of lawyers. Someone could be preparing whatever documents you want to put in while you're here. And therefore, I think we will stand by the order that we made.
Fair enough. I'm guided, my lord. I just want to bring it to your attention, but I'm guided.
Thank you.
My lord, my ladies, with your very, very kind indulgence, again, my name is Gumbo. I want to plead with you, my lords, to just give me 1 minute to be able to make an observation in relation to what Dr. Mudomi Tankolu mentioned to you. The disadvantage that I had is that he spoke after I had addressed you, and then he raised an issue which I didn't get an opportunity to perhaps mention or give any indication on. He introduced an issue in relation to paragraph 734 of the judgment, and then made a comment that the reason why we are seeking to introduce the Gazette notice is so that we run away from the position that we took in the High Court. My lords and my lady, I wanted to just point out that quite perhaps number one, and more very importantly for us, that issue is one of the grounds of appeal that we have. The issue of the mischaracterization of continuous registration of voters, and you heard Dr. Diankolu say that we talked about revision of the register. My lords and my ladies, the issue that then we'll need to make clear in the main ground of appeal is the mischaracterization of the use of the word revised and continuous registration of voters. So kindly, my lords and my ladies, have that in mind, because it is an important issue that arises from a misreading of those two statutes. Most of that.
All right. I hope we can now continue. We have spent about 35 minutes on some procedural aspects. I think it is not time wasted, but we must be able to move on. Mr. Ogeto, you are just beginning, and so the time will run from now, your 2 hours. It is 10:07. Proceed.
Thank you very much. My lords, my ladies, let me start, my lords and my ladies, by saying that it will be amiss of me not to say how deeply honored I am this morning to appear before you on behalf of the Honorable the Attorney General. And before I proceed, my lords, my ladies, I know you had given us 2 hours to do our submissions, and that applies to all the appellants. But I just want to point out to my lords and my ladies that the team of His Excellency the President has very graciously donated 30 minutes, 30 extra minutes to us. And that is the result of the fact that we cover much more ground in terms of our grounds of appeal. And so, my lords, I just want to notify the court that instead of the 2 hours, we also have 30 minutes from His Excellency the President for us to be able to be helpful to the court.
Well, that's what we said in our direction. As long as the issues that you're covering are cross-cutting, and those who are coming after you will not be requiring to take an equal amount of time on the same issues. It is okay, as long as you have organized yourselves.
So thank you very much, my lord and my lords and my ladies. Lords, we have filed 31 grounds of appeal, and those grounds will be found at page 1 of our volume 1 of our record of appeal. But we propose, my lords, to argue those grounds in the form of thematic areas. And allow me, my lords, to outline those thematic areas and to place our appeal in proper context. The first...
How many are the thematic areas?
The thematic areas, my lord, are 9 thematic areas. The first thematic area is the applicability of the basic structure doctrine, and that will cover grounds 1 to 5, 17 and 18. The second thematic area will be the constitutional remit of popular initiative and the question of public participation, grounds 7 to 17. The third thematic area, my lords, my ladies, the creation of additional constituencies, ground 24. The question of presidential immunity, the fourth thematic area, that will cover grounds 19 to 23. The fifth thematic area, the quorum of the Independent Electoral and Boundaries Commission, grounds 25 and 26. The sixth thematic area, adequacy of legal infrastructure to support signature verification, grounds 27 to 29.
Yes.
The seventh thematic area is the single or multiple referendum questions, ground 31. The issue of voter registration as relates to holding of a referendum will be the next one. And finally, and that will cover ground 30. And
yes.
Finally, the question of the role of amicus curiae, ground 6.
All right, start with the number 1, the applicability of basic structure doctrine.
Well, lords, the way we want to do that is that my colleagues will handle each of those thematic areas.
Right.
But for me, I want to give you highlights of the essential aspects of our appeal. Then I'll let my colleagues deal with the specific aspects of these thematic areas. In other words, I just want to do an opening statement, my lords. My lords, let me start by stating at the outset that our appeal is nothing more than a plea to this honorable court for fidelity to our constitution. It is simply a call to this honorable court for the restoration of the people's sovereign will. Through our appeal, my lords, my lords, we invite this honorable court to affirm the Constitution as enacted by the people of this great republic. We also invite this honorable court to affirm that it is not for this court or for any other court to rewrite our Constitution. My lords, my ladies, our submissions will seek to demonstrate, among other issues, that 1, the learned judges of the High Court disregarded clear provisions of the Constitution in order to arrive at their decision. Number 2, the learned judges effectively amended the Constitution. Number 3, the learned judges of the High Court disregarded decisions made by their colleagues in the High Court, in the Court of Appeal, and indeed the Supreme Court. And 4, the learned judges disenfranchised millions of Kenyan voters by ignoring their popular initiative. We will be submitting that the judges did this through personalized attacks against His Excellency the President of the Republic of Kenya that climaxed in factually and legally unfounded conclusions. An example of this, my lords, my ladies, is the unprecedented finding that a president can be sued in a personal capacity for official acts. On the disregard of the Constitution, my lords, my ladies, we will demonstrate that our Constitution has no place for the application of the basic structure doctrine. Chapter 16 of our Constitution, my lords, my ladies.
Just wait. Can you just repeat? The plane was passing by making noise. Just repeat.
Sorry, my lady.
Before you come to, just repeat what you are saying before you come to what you want to start on now.
My earlier submission, my lord?
No, her ladyship is saying that there was loud noise from a passing helicopter. She requests that you repeat what you just said, the last statement. I think about the basic structure.
After the personal attacks to the president.
Okay. On the disregard of the Constitution, my lords, my ladies, we will demonstrate.
I think, Mr. Ogeto, the last thing you addressed before the plane took your voice away was something about the Constitution having no place for something, for the basic structure, I think. That's what you need to repeat for
Yes.
us to get it right.
Yes, and what I'm saying in our submissions, my lords, my ladies, is that our Constitution has no place for the application of the basic structure doctrine. Chapter 16 of our Constitution, my lords and my ladies, provides that our Constitution may be amended either through parliamentary initiative or popular initiative. The chapter confirms that all the provisions of our Constitution are amendable. Articles 255 and 257 in chapter 16 direct us in very clear detail how the Constitution may be amended. The provisions, my lords, my ladies, tell us which amendments require a referendum and those that do not require a referendum. The provisions prescribe the majorities required in either House of Parliament to pass an amendment. They also guide us on the majorities required to pass an amendment in a referendum. We submit, my lords, my ladies, that there is no limitation to this amendment power. Our Constitution, in other words, is self-contained. There is no room for drawing inferences on the rules of amending the Constitution or for relying on extraneous factors. There is no mention in our Constitution of unamendable or eternal clauses in our Constitution. The learned judges themselves admitted as much in paragraph 473 of their judgment when they noted, and I quote, "To be sure, there is no clause in the Constitution that explicitly makes any article in the Constitution unamendable." End of quote. Yet, my lords, my ladies, the learned judges proceeded to conclude that the basic structure doctrine was applicable in Kenya. To be clear, my lords and my ladies, Many of the democracies desiring to make their constitutions unamendable have done so explicitly. And we have examples which we have articulated in our submissions. Germany, Italy, France, Senegal, Gabon, and Morocco. We shall submit, my lords, my ladies, that courts have adopted the basic structure doctrine where amendments are exclusively by Parliament. We do not have a single decision globally where courts have declared that the basic structure doctrine applies in a situation of a referendum.
Perhaps, Mr. Ogeto, when you get to the meat of that, you might want to address the issue of Colombia when you get to the meat later on.
We will do that, and in Colombia what they've done, my lords, because we have looked at that constitution, is that where the intention of the makers of the constitution intended that you have a constituent assembly, they provided for it expressly in their constitution. We shall demonstrate that the people of Kenya consciously and deliberately avoided the basic structure doctrine. They chose a different method of safeguarding the fundamental provisions of their constitution. This method is what is laid down in chapter 16. Once this method has been followed, the people of Kenya can amend any provision in their constitution. Chapter 16, my lords, my ladies, was our balance between hyper amendment, which was the concern of the High Court, on the one hand, and rigidity on the other hand. And we invite my lords and my ladies to look at the final report of the Constitution of Kenya Review Commission 2005. This report, my lords, emphasized the need for this important balance at page 74 of that report. And we have reproduced that report.
Yeah, where is it contained? In the record of appeal, please?
Contained at page 12 of the amended case digest and pages 49 to 51 of the appellant's abridged bundle of authorities. And if you allow me, my lords, my ladies, just to quote briefly from this report, they quote what they said: there is need to protect the Constitution against indiscriminate amendments. If the amendment procedure is too rigid, it may encourage revolutionary measures to bring about change instead of using the acceptable constitutional means. Thus, and that is important, my lords, a balance must be struck between these two extremes. At page 75 of the report, the Commission proceeds as follows, and I quote: many Kenyans expressed fears that even after a comprehensive review of the Constitution, Parliament, and the emphasis on Parliament, Parliament may thereafter sit and make substantial amendments that would water down all their efforts. In addition, it was generally felt that the current provision for amending the Constitution was too simple and therefore been used to consolidate power in the executive. The people, therefore, wanted fairly rigid arrangement, the amendment of which would require their participation in some form. This is what the CKRC report says. On this basis, my lords, my ladies, at page 76 of that report, there was a recommendation for a distinction in the amendment procedures for entrenched provisions and non-entrenched provisions. And my lords, my ladies, This distinction in the CKRC report is exactly what is reflected in Chapter 16 of our Constitution. This chapter captures the people's concerns and aspirations with regard to the power to amend the Constitution. We submit that it balances between rigidity and amendability. There was never an intention to make certain parts of our Constitution unamendable, because if that was the case, then the makers of our Constitution would have expressly stated so in the Constitution. My lords and my ladies, we shall demonstrate that in practice, Chapter 16 has been very successful in safeguarding the Constitution against the culture of hyper-amendment. You will notice, and we have demonstrated that in our submissions, that since the promulgation of the Constitution, there have been approximately 22 failed attempts to amend it. 2 through popular initiative and 20 through parliamentary initiative. And we have detailed those in Schedule 2 to our submissions dated 8th of June 2021. On the second issue, my lords, my ladies, we shall show that the learned judges effectively purported to amend the Constitution under the guise of interpretation. In paragraph 474G of the judgment, the learned judges say that the purportedly unamendable and eternity clauses would be determined by the courts on a case-to-case basis. My lords, my ladies, we need to note this very carefully. And if this understanding is to hold, the courts would have the role of vetting proposed amendments before the same are dealt with in accordance with Chapter 16. And yet, my lords and my ladies, there is no such role for the courts in our Constitution. In paragraph 615 of the judgment, the learned judges held that each of the proposed amendment clauses ought to be presented as a separate referendum question. We submit, and we will provide details in our submissions, that this holding clearly contradicts Articles 257(10) of the Constitution, which identifies in very clear terms that an amendment bill as the subject matter of a referendum. In paragraph 546 of the judgment, the learned judges impose limitations on presidential immunity. This, again, we submit, my lords, my ladies, contradicts Article 143 of the Constitution, which gives a serving president absolute immunity from civil proceedings while exercising his official functions. On the third matter, my ladies and my lords, we shall show that the learned judges ignored court decisions from their own High Court, the Court of Appeal, and even the Supreme Court. In this regard, we shall point out the following. 1, the learned judges ignored decisions to the effect that Chapter 16 provides adequate means for amending the Constitution. And 2, just as illustration, the learned judges ignored a finding by the High Court that the IEBC, as currently constituted, are quorum. In paragraph 491 of the judgment, the learned judges claimed that the popular initiative mechanism is exclusively available to the private citizen, as opposed to a state organ or His Excellency the President, or more generally the government. My ladies and my lords, we shall show that the learned judges established a non-existent dichotomy in the use of the popular initiative. And by this, the learned judges disenfranchised nearly 4 million registered voters under the pretext of nullifying alleged unconstitutional acts by His Excellency the President. Our very humble view, and with utmost respect, my lords and my ladies, is that the essence of a popular initiative is that it has to be popular by satisfying the majorities stipulated in the Constitution and nothing more. The initiative only becomes an initiative upon obtaining the endorsement of at least 1 million registered voters. The Constitution is very clear. It does not provide for the origin of a proposal to amend the Constitution through popular initiative. There is also no basis, my lords, my ladies, for the claim that the popular initiatives are by definition anti-government, because this was the finding of the Superior Court. And you will notice, my lords, my ladies, that this regrettable claim resulted partly from the learned judges' reliance on Wikipedia. They resorted to Wikipedia as an authority. And for sure, Wikipedia cannot be a reliable authority for anything serious, my lords, my ladies. If you look at Wikipedia, if you do a Google search of Wikipedia, it describes itself, and I quote, the free encyclopedia that anyone can edit, end of quote. So therefore, my lords, my ladies, a source that is so open to manipulation cannot be a reliable source of legal authority. In paragraph 490 of the judgment, the learned judges held that the Constitution of Kenya Amendment Bill 2020 is an initiative of His Excellency the President. My lords and my ladies, this was a fundamental factual error on the part of the judges. To be clear, we will be submitting that nothing in the Constitution prevents His Excellency the President from originating an amendment proposal to the Constitution. Even so, in the present case, my lords and my ladies, His Excellency the President never played the role that the learned judges claimed that he did. The learned judges simply ignored the evidence that was adduced as to who the promoters of the amendment bill were. And with utmost respect, my lords and my ladies, it seems to us that the learned judges were keen on very personalized attacks against the person of His Excellency the President. To them, the facts and the law did not matter. Neither did precedent nor the sovereign will of the people of the Republic of Kenya. The person of His Excellency the President just had to be found at fault, regardless of the consequences of such a finding on the people of Kenya and their sovereign power. In sum, my ladies and my lords, we will demonstrate that the learned judge's verdict was only possible because they either ignored or amended the Constitution and the law. At the end, the judges elevated their personal opinions and preferences over the Constitution and over the will of the people of this great republic. And therefore, my lords and my ladies, our plea to this honorable court is that it reverses the extra-constitutional and anti-constitutional step taken by the High Court. We urge the court to affirm the letter and the spirit of our Constitution. My lords and my ladies, we humbly invite you to end this clear onslaught, and we call it onslaught, in a very considered manner, on the sovereignty of the people of Kenya. We submit that the people must retain their sacrosanct right to live by the Constitution that they chose for themselves and to develop it as they may wish. That is the only way to preserve a rule-based civilization. And I wish to quote the famous Irish philosopher Edmund Burke, who has warned us, and I quote, "A state without the means of some change is without the means of its conservation." End of quote. My lords and my ladies, as I conclude, and with your kind permission, I should like to indicate that my learned colleagues will address the various topics of our submissions in the following order. Mr. George Oraro, Senior Counsel, who is leading us, will address the question of the applicability of the basic structure doctrine, public participation, and the approach to referendum questions. Mr. Kamau Karori will address the question of the remit of popular initiative and the creation of additional constituencies and the quorum of the IEBC. He will also deal with the question of amicus curiae. With your permission, I will return to address you on the question of presidential immunity. My learned friend, Mr. Nyamodi, with your permission, will be replying to the respondent's submission. Thank you very much, my lords.
Okay. Just hold on. Let him answer, so that we take a break now and continue. All right, thank you very much, Mr. Ogeto, for that introduction of the issues that are going to be dealt with and the order in which council you're appearing with will address the issues. What we intend to do is to take a short break now. We craft a short ruling, and when we come, we now begin with the senior counsel, Mr. Oraro, and then we continue with the others who are addressing the thematic areas.
Thank you, my lord.
Yes.
I'm obliged.
All right. So we'll be back after about 30 minutes.
Presume this is the tip. This is the tip. This is the tea break. Yeah, because I can't hear speaking. And then we go for tea break. I think we started well. I was expecting many more objections, but no.
Do you know what clubfoot is? The causes, the treatment, and prevention.
references or cross-references to the references that we make in the digest and in the bundle of authorities. We have also filed an amended digest, and the amended digest, like the cross-reference submissions, contains references to the substantive bundle. And we also, after going through our list and bundle of authorities, and we found that it goes to 5,318 pages, we also filed an abridged bundle of authorities. And the abridged bundle of authorities is dated the 28th of this month, and it is filed in this court also on the 28th. And what the abridged bundle contains is only the relevant material that we wish to refer on. If it is a scholarly article, then it is only the part of the scholarly article that we wish to rely on. And if it is a judgment, members of the court, then it contains only the extract of the judgment. The full articles and the full judgments are contained in the substantive list and bundle of authorities. So we have done that so as to make it easier. There are large and voluminous documents, and I wish to perhaps request that when you retire, it may be easier if you look at the amended list and digest, because in the amended list and digest you will find the references to both the substantive material and to the material in the abridged bundle. We have also filed submissions in reply, and these submissions in reply are dated the 26th of this month and filed on the 26th of this month. We have filed a supplementary case digest also on the 28th and filed, so also dated 28th of this month and filed on the 28th, and a supplementary list and bundle which is also dated and filed on the 28th of this month. In our reply, in our supplementary case digest, we have referred again, it is cross-referenced, unlike the original submission. So it contains the page numbers of the page numbers in our bundle and in our digest of the cases and of the scholarly articles that we wish to rely on. We have done that so as to try and make the work of the court easier, and to perhaps try and make the material that we have shared with court more intelligible. I'm most obliged.
Thank you.
My lords, my ladies, my lords, perhaps I would begin with the issue raised by Justice of Appeal Piage on the Constitution of Colombia.
You are addressing us on the basic structure doctrine?
Yes, my lord. My lord, I will address you first on the basic structure doctrine, and thereafter I will address you on the issue of violation of Chapter 6 by His Excellency the President, and then I'll address you on the proposed amendments, whether they should be separate and distinct memorandum questions, and finally I will address you on public participation in the context of popular initiative. My lord, on basic structure, I just wanted the Solicitor General promised that we would address the issue of the Colombian Constitution, and perhaps that's the best place to begin before I tackle the main issue. My lord, it is important to note that the Colombian Constitution under Article 37 has a provision which allows a constitution to be reformed. The word used is reformed by Congress, a constituent assembly, or by people through a referendum. So that when one of the bodies exercises that right, it is then not exercised by the others. Unlike ours, where the amendment provision is based on purely a referendum by people exercising their power through that process. Now, the next issue on the Colombian Constitution is that it is well known that Colombia is a divided country under war, and that within Colombia you have the rightist militias, leftist guerrillas, and narco-traffickers, and therefore their constitution is predicated on addressing those particular issues, and it is therefore an outlier in considering the structure of the constitution provisions. Now, the issue at hand, where the courts carried out a review and declared a proposed amendment unconstitutional, was in connection with the election of a president, which had earlier been allowed contrary to the constitution. But when he came the second time, the position of the Constitutional Court was that by giving him a second opportunity to violate the term limit under the Constitution, he would be in a position where he would control the appointments to the constitutional institutions by way of having served for unduly long term, and that was the rationale behind that decision. So, my Lord, I would humbly submit that the Colombian example would not be an appropriate example to be adapted in our context. Having said that, my Lords, I now come back to addressing the issue which is before your Lordship, and that is the court's finding on the issue of basic structure doctrine. Now, I will begin by referring your Lordship to a matter my learned friend Mr. Ghetto adverted to, and that's the finding at paragraph 474G of the judgment. My Lord, you will find this finding in our supplementary record of appeal 1A, and the page I'll refer to is page 179, and that is where the court found that the basic structure document protects the core edifice and foundational structure and value of the Constitution, but leaving open certain provisions of the Constitution as amendable in as long as they do not fundamentally alter the basic structure. That notwithstanding, it proceeded further to state that certain provisions in the Constitution which are inoculated from any amendment at all because they are deemed to express categorical core values. These provisions they termed as being unamendable and also as being eternity clauses. So according to the judges, by applying, notwithstanding the provisions of the Constitution which I will come to, by applying the basic structure doctrine, some of the provisions of the Constitution will be unamendable and therefore they form eternity clauses. They then went further to determine how these eternity clauses would be addressed. And at paragraph 474E, and that the court will find in the Attorney General's supplementary record of appeal 1A, dated 8th June 2021, they say that the basic structure could only be altered or modified by the people exercising their primary constituent power, which would involve civic education, public participation, debate, consultation, and public discourse, and a referendum. So that there are some core values in the Constitution, never mind Article 155(1), which can only be altered in a constitutional moment. That was their finding. Now, it is not in dispute that the common scheme adopted for creating unamendable provisions is by expressly stating them in the Constitution. And my old friend, Mr. Ghetto, outlined some of the countries where their constitution contained unamendable clauses. And the examples were like Germany at clause 79(3) of their constitution, France Article 89, Angola at Articles 236 and 237, and many other countries. So the best way of ensuring that you have unamendable clauses is to ensure that they are expressly stated in the Constitution. As stated, it is not in dispute that our Constitution does not have unamendable clauses. My Lord, that was indeed the finding of the learned judges at paragraph 473 of their judgment. And you will find that at page 176 of the Attorney General's Supplementary Record of Appeal 1A. Indeed, the learned judges went further to concede at paragraph 402 that the Constitution conceived in Kenya was a model participatory constitutional building process, and you find that at paragraph 402 of their judgment and paragraph 403. My Lord, each chapter of our Constitution is a product of development and reflection, and thereafter endorsed by the people through a referendum. In fact, the amendment provision at chapter 16 has its own constitutional history. As you are referred to, I don't need to read it again. The history of chapter 16 is found at page 47 of the CKRC report. And my Lord, that you will find in your record at page 1080, volume 3 of the Attorney General's bundle of authorities dated 9th June 2021. And my Lord, my ladies, the other provision dealing with history of the amendment chapter at chapter 16 is found at chapter page 76 of the CKLC final report, and you will find that in pages 1082 to 1083 of volume 3 of the Attorney General's bundle of authorities dated 9th June 2021. So the chapter on amendment collected the views of the people of Kenya, was debated, a finding was made, and the text was then formulated. In fact, it is conceded again in the judgment by the learned judges at paragraph 427, and you'll find that at page 158 of the Attorney General's Supplementary Record of Appeal 1A dated 8th June 2021, that draft constitution that emerged in October 2002 was a reflection of the true will of the Kenyan people. And that is what has been reflected in this constitution. At the end of it, there was then the draft by the CKRC, and it is the provision in that draft that was then incorporated into the WACO draft at chapter 19. And that is found at page 1978 to 1980 Volume 4 of the Attorney General's Bundle of Authorities dated 9th June 2021. What is clear in that bundle is that it mirrors almost word to word what is contained in the current Constitution. Again, when it came to the harmonized draft, the same Chapter 19 which was incorporated into the WACO draft was once again incorporated into the harmonized draft, and you will find the harmonized draft at page 2266 to 2669 of Volume 4 of the Attorney General's Bundle of Authorities dated 9th June 2021. At the end of it, there is no doubt whatsoever that Kenyans have had no dispute whatsoever or controversy as far as the amendment representation of the view of the Kenyans on how they want their constitution to be amended, and the view taken amendment conference and move ending up with our new constitution. So, when you look at the history, it is very clear that the issue of entrenchment through express provision was considered and not found appropriate. Yes.
Mr. Oraro,
yes, madam.
You say it was considered and not found appropriate. That's an important submission.
Yes.
Are you able to point out where exactly it was considered and rejected, found not appropriate?
My Lord, if you look, page 76 of the report of the Commission states as follows, that the new constitution should have some entrenched provisions, for example, in human rights, that Parliament does not have the power to amend. The new constitution should address the issue of relationship between the various organs of state and must deal with checks and balances. The new constitution should have supremacy clause that could state that the constitution is binding all the people and all organs of state. The constitution should only be amended by at least 75% of the members of Parliament, and the amendment procedure should make the following distinction, and the distinctions are placed there. And then the considered non-entrenchment but special provisions and the bill which would require amendment of the provision. So at that page, the Commission considered the alternatives to amendment of the Constitution and eventually came up with the formulation which is now contained in the Constitution. So entrenchment was not an option. It was how to secure an entrenchment through an arduous procedure, and which involves various organs of the state and the people.
Do we have an express rejection of an attempt at entrenchment?
My Lord, I think when we read the meaning of the recommendation at page 76, it amounts to very implicit intention not to entrench it in the context of express provisions in the Constitution. Because if that were the position, then they would have, in fact, the first issue was a bill seeking to amend an entrenchment should not be passed unless, and therefore the entrenchment was through making a provision that nevertheless we should have an arduous process of ensuring that any amendment which goes to the structures which are created in the Constitution are passed through a very arduous process. I think that was the intention. And indeed, it was then reduced to a draft. And that draft has remained consistent, and more importantly, the people of Kenya have endorsed that draft in a referendum. So it has been expressly accepted by the people of Kenya. Now, my Lord, I had as I was saying, I'll go through the rigorous process which was then proposed and endorsed by the people. My Lord, in endorsing that rigorous provision, it was clear that it was not the intention that there should be some form of external application to the Constitution of Kenya which would limit the power the people had granted to themselves. And in considering this, we should take into account that amendment provisions in the constitutions are not polymorphic. Every constitution has its own amendment procedure, and none is like the other. In fact, the text of our amendment is unlike any other constitution. And it is with this in mind that the Supreme Court has consistently warned of the danger of mechanistic approaches to the adoption of foreign jurisprudence and foreign principles, as it underscored in the case of Jaspir Singh Rai and three others versus Talochan Singh Rai. It is found in our list of authorities at page 332, volume 7 of the Attorney General's Bundle of Authorities dated 9th June 2021. And this is what the Supreme Court said. In the development and growth of our jurisprudence, Commonwealth and international jurisprudence will continue to be pivotal. However, the Supreme Court will have to avoid mechanistic approaches to precedent. It will not be appropriate to pick a precedent from India one day, Australia another day, South Africa another, the US yet another, just because they seem to suit the immediate occasion. Each of these precedents has its place in the jurisprudence of its own country. A negative side of mechanistic approach to precedent is that it tends to produce a mindset. If you have not done it before, why should we do it now? The Constitution does not countenance such a predetermined approach. All the cases cited in this matter were subject to an inquiry into the respective context. We sought to find out whether they are still good law or have been overturned. We did all this because our progressive needs under the Constitution are different, and there is the need to bear in mind that our Constitution remains always, as our brother Judge Ojwang had emphasized, a transformative charter of good governance. So as we look at this constitutional principle, which incidentally is being applied for the first time in Kenya, applying the basic structure doctrine to a constitution which is predicated on amendment by a referendum is being applied for the first time in Kenya, in the whole world, based on constitutional theories. The court itself was conscious of the necessity not to blindly apply foreign concepts, and it stated so in the case of Gitarau Munya and Dixon Mwenda Gethinji at paragraph 399D of their judgment. And you will find that at page 147 to 148 of the Attorney General's Supplementary Record of Appeal 1A dated 8th June 2021. Now, in going through the judgment, you will not find any place in the judgment where the court clearly analyzed the provisions of Chapter 16 against the basic structure doctrine which they have found to be applying in Kenya. My Lord, in order to do that, it is important to go on to the Constitution itself. My Lord, we begin with Chapter 255(1), which provides a list of matters in the Constitution which must be subjected to referendum. Unlike many constitutions, our Constitution clearly specifies those parts of the Constitution which can only be changed by referendum. And in such a referendum, my lords, my ladies, Article 255(2) provide that the amendment can only be approved by 25% not of voting but registered voters in at least half the counties, and must also be supported by a simple majority. This is much more exacting than the standard set for election of the president at Article 138(4). And indeed, it is a procedure which is much more rigorous than we adopted for the passage of our current constitution. So you begin with that at the threshold of a referendum. Now, it goes further to state that the matters specified in Article 255(1) can either be initiated by Parliament or by Parliament and the people. And it's important to appreciate that popular initiative, unlike the popular initiative elsewhere in the world, in Kenya, it is an initiative by Parliament and the people. And therefore, it is an organ of the state and the people involved in initiating such an amendment. Now, to begin the process, it is provided that popular initiative must be proposed by at least 1 million registered voters. Again, very important to emphasize that the 1 million threshold has only been applied for the first time in Kenya. Everywhere else you have 100,000. I think Switzerland is 100,000. Other countries are perhaps less. But there is no country in the world which puts a threshold of 1 million as the commencement of a process towards popular initiative. Then it requires the signatures of those 1 million people to be verified independently by an independent commission established under the Constitution, and that's IEBC. That is at Article 2574. Then, once it has been verified, then it now goes to the second level of governance. It is then required to go to the county assemblies for consideration. Article 2575. In going through county assemblies, it is important to take into account that the county assembly are required to ensure that any legislation they pass is subject to public participation. Then, if half the county assemblies pass the bill and provide a certificate to the speakers of the two houses of parliament, then the two houses of parliament will then debate and either pass or reject the bill, and that is found at page 576. And I would like to emphasize that as a precursor to passing the bill, the County Assembly, Article 196(1) requires them to hold the deliberations and in an open manner and facilitate public participation. And Parliament, when it reaches Parliament, Article 2562 requires Parliament to publicize the bill and facilitate public discussion. So at all these levels, there is a requirement for public discussion. then, if both the houses pass the bill, it is taken to the president, who takes it to the IBC for referendum. But if one house does not pass the bill, then it is then taken to a referendum in any event, that is under Article 257(10). However, if both houses don't pass the bill, then it is not taken any further. So that is why this is a process which is through the people and with Parliament. But it is important also to take into account that the judiciary is not left out in this process. The judiciary has still got its obligation under Article 258 to ensure that these processes are conducted in accordance with the Constitution. In the result, we have a process which is in conformity with Article 11, 12, and 13 in incorporating an amendment provision which can only be carried out if it affects those matters specified in 255(1) through the sovereign power of the people and involving all organs of the state. And that's how this very unique amendment provision was incorporated, and it is clear that Kenyans wanted to incorporate an amendment provision which suits their circumstances. Now, my lords, my ladies, if there was any doubt as to the robustness of a referendum, I think the testament is on the rejection of WACO draft, which the executive tried to push through without endorsement at various levels, and the people exercised their sovereign power to reject it. You don't need the court to reject it. The origins of basic structure doctrine. The basic structure doctrine is a constitutional theory which has existed intellectually and has been debated for a long time. But it received its validation through the case of Kesavananda Bharati versus the state of India.
Okay, state of Kerala?
Yes, state of Kerala. Thank you, my lord. Sorry. And my lord, in that case, the Supreme Court held that the power to amend the Constitution did not include the power by the Parliament to alter its basic structure or its framework. Of note is that the decision was predicated on the power to amend by Parliament, which was a similar provision to our repealed Kenyan Constitution. And therefore, it was a power exercised by a constituted organ of the state or under the Constitution, and not a constituent organ. While the doctrine received endorsement in Bangladesh, it has faced stiff resistance in other jurisdictions, including Malaysia, Singapore, Pakistan, Sri Lanka, Zambia, Uganda, Tanzania, South Africa, and many others. Indeed, an implicit power to limit the power of amendment in the Constitution has faced stiff resistance even where the power to amend is solely in Parliament. So it is inconceivable that we can attempt to incorporate the doctrine in a situation where power to amend has been conferred on the sovereign power of the people. The doctrine has fallen for consideration before the recent decision in two earlier decisions by the High Court. And that was the case of Timothy Njoya versus Attorney General, and that is found at page 159 of the Attorney General Supplementary List and Bundle of Authorities dated 28 June 2021, where it is important to note that the court considered the doctrine, found that in view of the provisions of Section 47 of the then Kenyan Constitution, the repealed Constitution, there was no necessity of importing the doctrine. But then, nevertheless, the court approved the dicta only to the extent that Parliament did not have power to amend the basic structure of a constitution. Since then, we have gone beyond that, and we have now placed that power in the hands of the people through referendum.
Senior Counsel, did that case of Njoya define what it considered the basic structure was?
All it dealt with, it didn't define basic structure as such, but it dealt with basic structure as a limitation to for the power of Parliament to amend a constitution. But proceeded to find that in Kenya we were not dealing with amendment, we were dealing with a review, and therefore it didn't apply in the context of the issues arising in Kenya at that time. Yeah, but it didn't define exactly what the basic structure was. And it has to be remembered, my lord, that the Casavananda case was not a case on amendment of the constitution as such. In fact, it arose out of a struggle between the Indian Parliament on issues of land and the Supreme Court. The Indian Parliament was trying to take out the entrenched provisions which protected land tenure in the state. And therefore, the Supreme Court deemed this to be amending a provision which affected the basic structure of their constitution.
Senior Counsel, in your view, what is the contextual relevance, similarities or differences between the Indian Constitution, the Kenyan Constitution in relation to the Casavananda case?
There's no similarity at all, because first and foremost, India is a federal state. Secondly, the Constitution of India was a negotiated constitution out of the Westminster system, which has been amended from time to time. Thirdly, the Indian Constitution is predicated on the power of amendment conferred to Parliament, which is a constituted power. It doesn't give the Indian people the right of altering any provisions of the Constitution through a referendum. So it is a completely different circumstance. And lastly, it has to be remembered that the Kenyan Constitution is not just an issue of a referendum. The Kenyan Constitution incorporates every organ of the government in the process of implementing popular initiative. The electoral authority, it involves the county government, it involves Parliament, it involves the President, and it involves the judiciary. That is not the situation in India. So Casavananda cannot apply in our circumstances.
Sorry, Counsel. I'm just wondering, from where you stand, is it your position that there are no parts of the Constitution to amend which will be to significantly alter its character.
My Lord, I would approach it from...
Let me just finish that thought.
Yeah.
For example,
yes,
the Constitution says that there shall be 290 parliamentary seats.
Yeah.
Altering that from 290 to 230, 230 or 330,
yeah,
is it the same as altering it to say that there shall be no parliament? I mean, that's crazy, right? Supposing someone would come up with an amendment to say that parliament stands suspended for a while, and you go through the motions of amending it, would you say that the two amendments are the same so long as the process is followed?
My Lord, they are not the same, but the Constitution has provided a procedure for dealing with that issue. The Constitution has provided a procedure, and that procedure has to be strictly complied with. And if it is complied with, then it protects the people of Kenya fully.
Mr. Orero, that's my question.
Yes.
Supposing
yes,
you follow the procedure
yes,
that is set out in the articles you refer to.
yes,
You have whether a parliamentary initiative or a popular initiative.
yeah,
You take it through, you pass the draft, it is sent, the bill, it is sent to the houses of parliament, it is sent down to the county assemblies. You actually go ahead and have 1 million signatures, and then you go to a referendum, and you pass that parliament shall not exist in this country. Does that not alter the basic structure of the current constitution to the effect that, let me finish, to the effect that one might say what you are doing is not just amending the constitution, but basically altering it, totally changing it to something else?
My Lord, it would be an alteration, but our Constitution has provided for it. And what we are objecting to is borrowing a foreign doctrine to substitute what our Constitution has provided for. It has provided for sovereignty of the people. If the people of Kenya don't want a parliament, you can't stop it by applying the doctrine. Because the people of Kenya have said, you want to alter the structure of our Constitution, come back to us. And that is what we did by passing the 2010 Constitution.
Sorry, I'm taking a bit of your time. Let me just follow that a bit.
Yes.
Is it not the thinking of the judges in the court below that if we want to do that fundamental change of that nature, it's okay, but beyond following what is in 255, 257, you must also ensure there is real public participation. You must ensure that there is civic education, and you must ensure that there is a constituent assembly. So they will still have their way. They'll have their way, the Kenyans will, but not merely by way of parliament and referendum, but there has to be something more. Isn't that what they're saying?
My Lord, that is what they're saying, but it's contrary to the provisions of the Constitution, because the Constitution has by itself provided the manner in which the public must be involved prior to a referendum. And it includes, 1, at the county level, 2, let me just get my Constitution along. My Lord, if you look at 256, 2, it is the only other time, while there is the general obligation of Parliament to encourage public participation, 256.4 is the 256.3, no, 256.2 is the only provision in the Constitution which wants Parliament to publicize the bill, to amend the Constitution, and to facilitate public discussion. It is the only one. Yes. So we have provided for it in our Constitution. Why then would judges decide that they are placing a threshold on how an exercise which has been fully provided for in the Constitution can be carried out. Now,
Senior, before you proceed on.
yes.
Don't you think that is the reason as to why we are all gathered here?
Yes.
Why we are all gathered here?
Yes.
The court said that a certain procedure or an aspect of it touching on public participation was not followed. But your argument is the public participated. You can
I am saying that the public have a right indeed
Yeah, thank you. I'm just following up to what my brother here has said and what his senior has. You can't hear? Okay. Yeah, what I'm saying is, from what he has explained, following up to what my brother judge put to him, is indeed that the reason as to why we are here. If I have understood the judges of the High Court well, that the public participation was not followed. And you are saying they were satisfied or their rights were not trampled upon. Is indeed that the sole reason as to why we are here?
Not at all, my lady. The reason we are here is because the judges in the Superior Court, instead of determining whether the provisions of the Constitution had been complied with, have unilaterally set a standard. And that standard is a standard for a constitutional moment. They now want that before any constitutional amendment is made,
before any constitutional amendment or any touching on the basic structure?
In order to find whether it touches on the basic structure, they have set a standard which requires the court to examine it and find out whether it touches on basic structure or not. If you find it doesn't touch on the basic structure, then you can now go and affect it. But if it touches on the basic structure, then they have completely ignored the provisions of the Constitution and come up with a standard which is consistent with the standard we adopted for constitutional review, and which is civic education, public participation, debate, consultation, and public discourse. And that's why we are here. Had they merely said there is a right for public participation under the Constitution, it has not been conducted, we won't be here, because it would be consistent with the provisions of the Constitution. My lady, have I answered you? Thank you. Now, my lord, my ladies, this issue came again for consideration in the case of Commission of Implementation of Constitution versus National Assembly. That is found at page 4238, volume 8 of the Attorney General's Bundle of Authorities, dated 9th June 2021. I was in that case. My lord, that case again was an attempt by Parliament to amend the Constitution, which could have affected the basic, structure, my lord. And in that case, the position taken by the court was for the parties to wait for the bill to be passed, and after that, if they felt the basic structure was affected, come back to court. So it was not dealing with the situation which we are dealing with, which is an amendment by popular initiative through a referendum. It was again dealing with amendment by the Parliament.
My Lord, Senior Counsel, as you proceed, I need to remind you about the time.
Yes, my Lord.
Because the 2 hours allocated to Mr. Ogeto, you can see it's only 37 minutes to go.
Yes, my Lord, of course, it is important, and I humbly request we address any issues raised by your Lordship so that we can all live with a clear mind. And that has taken a bit of time. Be that as it may, we have 30 minutes more donated by the President's team.
All right, carry on,
Yes.
provided you remember that. Thank you.
Yes, my Lord, this issue, the issue of the amendment provision has come for consideration before a 5-bench of this court in the case of Senate and 48 others and Council of County Governors and 54 others. You find that at page 88 of the Attorney General Supplementary List and Bundle of Authorities dated 28th June 2021. And in that case, in fact, this court considered Kasavananda and found at paragraph 50 that in this matter, Article 255(1)(1) of the Constitution expressly states that any alteration to the object, principle, and structure of the evolved government can only be done by way of a referendum. That answers the question of what do you do with basic structure in Kenya. In fact, the court said that in India, it would be unconstitutional. But in Kenya, you can pass it through Article 255(1), and thereby disavowed the whole of this concept of basic structure. My lords and ladies, the issue again came for consideration in the case of Non-Governmental Organization Coordination Board and 5 others. That is found at page 40 of the Attorney General's Supplementary List and Bundle of Authorities, dated 28th June 2021. And again, there, Lady Justice Nambuye clearly said the Constitution itself has provided for methods for such entrenchment. Article 255(2) makes provisions for an amendment to the Constitution through a referendum. Article 256 through legislation, and Article 257 through popular initiative. None of these cover judicial pronouncement. And that's what the court has now done. They have now said, before you do any amendment, come to us. Now, again, it was considered by this court in a very serious case where some people in Kenya wanted to secede, and my Lord the President, you are in that case. And again, it was clearly held by this court that in view of the foregoing, the apparent conclusion that the respondent's agenda for secession is unconstitutional has no basis in law. The respondents have a constitutional right to demand secession, but can only be done within the confines of the Constitution as stipulated under Articles 255, 256, 257. They now want us to address the issue through an academic doctrine which has been validated by the Supreme Court of India. Now, my Lord, therefore, it is obvious that Kenya opted for a strong amendment power instead of entrenchment of the provisions which affect the basic structure. Now, my Lord, the issue where there is a referendum provision and an alteration to the Constitution has been effected, has been my Lord, I am told that some of the respondents will have decided not to address the court and would wish that this issue be addressed exhaustively. But when we exhaust...
Sorry, I didn't get you, Counsel.
My Lord, I am told that 2 respondents have indicated that they will not address the court.
They will not?
They will not address the court. Okay? Yeah, and therefore, any time they would have been given, be applied towards addressing this very serious issue. Okay. Yeah, so they say, my other friend tells me that they can offer 20 minutes of whatever time you give them. But be that as it may, we have not run out of time. Let me address this issue now.
Well, we had said that you can rearrange yourselves in such a way that one or two of you covers the substantive issues.
Yes.
I believe the basic structure doctrine is a major component of this appeal.
Yes.
And so you have a few more minutes, so just finish.
Yes. So, my lord, again, in this case of secession, the court very firmly affirmed that you can even secede from Kenya so long as you comply with Articles 255, 256, 257. And that is found at page 32 to 33 of Attorney General's Supplementary List and Bundle of Authorities dated 28th June 2021. Now, my lord, let's look at it from the other angle. How have other countries dealt with amendments carried out through a referendum? And in respect of this, I would like to refer you to the thesis by one of the leading scholars on the doctrine of constitutional amendments, and that is Yaniv Rosnai. And in his works on constitutional amendments, which you find at volume 1 of the Attorney General's Bundle of Authorities dated 9th June 2021, he refers to the reaction of countries to a challenge to an amendment which has been carried out through a referendum. And his first example is found at page 163, and that refers to the French constitutional change. And he says, the French Constitutional Council, which held that it has no competence to review laws passed by people in referendum. In that case, General de Gaulle passed a law through a referendum. Then it was taken to the Constitutional Council. But the Constitutional Council proclaimed that the power of the people is above everything else. And once a matter is passed through a referendum, the court has no basis or authority to question it. And hence the saying in French, le peuple roi. The matter again came up for consideration before the Irish Supreme Court, and that is found at page 164 to 165 of volume 1 of the Attorney General Bundle, dated 9th June 21. And the Irish Supreme Court held that people and not God are the creators of the Constitution and the supreme authority. Hence, amendment made by people become the fundamental and supreme law of the land. You can't question it. You can't deny the people the right of having a referendum. It is their government, it is their law. Again, it came before the Romanian Supreme Court, and you will find that as page 165 of his writings, and he says, the Romanian Supreme Court held that once an amendment is adopted by referendum as required by Article 151, it is definite and final, and the court has no control over it, since such a law expression of the original willpower is above the will of any power. So where you have a referendum, the courts cannot intervene. Now, in this article, Rosnai, who is a real adherent of the structural doctrine theory, nevertheless states at page 158 as follows: just as in material science, a solid material can exist in multiple forms, so does the amendment power. Constitutions have different procedures for constitutional amendments. Not only do entire constitutions differ from one another in mechanism, actors, and procedures, and ours is unique in the world, procedures involved in the amendment process, but also the same constitution might incorporate different procedures for amending different provisions and principles, like in ours. This section therefore argues that one ought to regard constitutional amendment powers not in a binary manner, limited and limited, but rather as a spectrum of scope, a spectrum of amendment powers. The more similar the democratic characteristics of the secondary constituent power are to those of the primary constituent power, strong amendment power, the less it should be bound by limitation, including judiciary, scrutiny, and vice versa. That is really the principle which ought to apply. And in considering this, a leading professor in Hong Kong, Professor Pojen Yap, in his work, The Conundrum of Unconstitutional Constitutional Amendments, has this to say. You find that at page 22 of the Attorney General's Supplementary List and Bundle of Authorities dated 28th June 2021. The people may not be always right. For popular sovereignty is not an absolute guarantee of substantive justice, but neither are the judges infallible in their moral deliberations. In these circumstances, the judiciary must cede to the expression of popular sovereignty. Judiciary must concede to the expression of popular sovereignty, not merely because the amendment is an unmistakable expression of public will, but because this convergence of interests is undisputable evidence of the triumph of the political process over the intervening institutional and electoral barriers erected by separation of governmental powers. Now, very profound ones. In the result, it is my humble submission that the doctrine of basic structure was not intended to apply to our Constitution. And just to give a very short summary, it applies limits to the power of constituted powers, and that is the Parliament, and cannot apply to amendment by people through a referendum. There is an academic debate out there, but it remains academic. It has not been applied anywhere in the world. Whether the basic structure doctrine applies to Kenya would be predicated on the form of amendment power as contained at Chapter 16, and it is obvious that Chapter 16 does not envisage any limitation. Further, our textual and historical analysis clearly show that it is not intended that there ought to be limitation in exercising the powers granted under Chapter 16. Finally, my Lord, the Superior Court has arrogated to the judiciary the right of determining what forms basic structure and what can be amended and what cannot. A power the people of Kenya have given to the people and all the organs of the government. Now, as a result of this decision, it is being contended that that power can be exercised by judiciary and judiciary alone. My Lord, in substance, this would amount to a repeal of Chapter 16 of the Constitution. And this would not have been the intention of the people of Kenya. My Lord, therefore, it is my humble submission.
Senior Counsel, before you finish on that argument.
Yes.
One of the submissions made by, one of the grounds advanced by the respondents in their submissions is that the appellants are applying what they have called textual interpretation as opposed to the holistic, purposive interpretation in the argument that...
My Lord, I have analyzed the text. I have also analyzed the textual consideration of the court by taking into account that this is a provision which involves all the organs of government established under the Constitution and then reverts to the sovereignty of the people. That is, the real spirit of the Constitution is contained in Article 1, and it states that the people may exercise their sovereign power either directly or through their democratically elected representative. Through their democratically elected representative, this right is being exercised through the proposals, the county governments, parliament, the president, but it ends up with direct exercise by the people of their sovereign right. And that's what defeats all these arguments. Here, we are being placed in a situation where, from time to time, people who have their own inclination on any amendment proposed can go and stop it and deny the people the right of making a decision. It is the right of people of Kenya to make a decision, and they have reserved that for themselves. And I have also analyzed the various institutions which are involved in the exercise of this power and how they engage the public in ensuring that they participate and debate the process before they exercise their power. And finally, if that is not done in the spirit of the Constitution, I have also said the court remains with the power to ensure, and it is a very wide and permissive power, to ensure that the spirit of the Constitution is carried out within the context of the provision. So one cannot say that that is a textual analysis of the provisions, and we have not gone on to the whole Constitution and seen how it relates to this. But more importantly, the history informs us of how this provision came into being.
All right, thank you. Thank you, Senior Counsel.
Thank you, Manad.
Before you sit, Senior Counsel,
yes,
you made a strong submission to the effect that once the people have decided, what they have decided is binding and really nothing matters. No one, the court cannot go against that.
No, Manad, what they have decided, the court has power, but the power granted to the court is only interpretation.
Fine. That's okay.
Yes.
And then you said that, in fact, that you seem to suggest that that is the policy, that is really the position worldwide. I'm looking at the gentleman that you quoted. You call him an authority in this area. In fact,
Rosman.
Yes, indeed. In fact, your first authority on the part of the Attorney General is actually his PhD thesis.
Rosna is an adherent of basic.
Yes, exactly. His entire thesis is here, titled Unconstitutional Constitutional Amendments, a study of the nature and limits of constitutional amendment process powers. Now, he talks about the case of Switzerland.
Yes.
And in Switzerland, what he says is 100,000 people, by way of referendum, they moved to say that any refugees who come to their country should be deported at the border without a right of appeal. Clearly, that was against the principle of non-refoulement. Now, when this matter came to the Federal Council, which really is their highest authority, judicial authority, the judicial authority actually said that that wasn't right, because even though the people had spoken, that which they proposed was actually against a principle of international law, and so they proposed to Parliament, to the Federal Assembly, to reverse the will of the people. So the court said, what the people have said goes against international law, and therefore it cannot stand. Do you find this an aberration?
Milord, I don't find it an aberration, because that came after the people had expressed their will. The people have to express their will. And when it comes to enforcement, then in our jurisdiction, the court has very wide powers of interpretation and to enforce fundamental rights. So if there is a constitutional provision which has been passed and violates certain fundamental rights, then the court will interpret it in that context. But the court cannot deny the people the right to decide whether there should be the amendment or not. Yes.
Okay.
Yes, thank you, my Lord. My Lord, I have two other issues to address very quickly before I leave for my learned friend Karorik Ma. My Lord, the next issue I want to address very quickly is the issue of the presidential liability for violation of Article 73A1. My Lord, I want to say very few words on this. I merely wish to say, my Lord, that Article 73.1
Yes.
is aspirational. It sets out the general principle and statement of policy to signify the value system, ethos, and cultures which are expected of state officers. The liability for violation of those principles are contained at Article 75, both for public officers and for state officers. But the President and many other officers, including that of judiciary, is a tenured office. And in every tenured office created by the Constitution, a provision has been made for how to deal with their violation. And for President, in the event he violates any provision of the Constitution, the path is impeachment by Parliament, not the courts. Just like, my lords, judges cannot be tried for violation by the court. They have to go to a tribunal set up under the Constitution. It is therefore my humble submission that this finding was against the Constitution. My Lord, I will move to my next subject, which is whether proposed amendments needed to be placed as separate and distinct referendum questions. My Lord, my first humble view is the judges, having determined that the basic structure doctrine applies and therefore the bill was unconstitutional, ought not to have gone more than that. But nevertheless, they went on to determine the issue of whether the referendum question should be biannual or each issue should be on a separate referendum question. And in saying this, they relied on Article 257.10. Now, Article 257.10 does not deal with the issue of question of referendum at all. It deals with a question where one house of parliament has not passed the proposed bill by popular initiative. The manner of presenting the bill to the people for a referendum is prescribed under Article 256.6. Now, it states that once the President receives the bill, he has to refer it to IBC, and the sole function of the IEBC is to certify after the referendum whether the bill has been approved or not. The purpose of the referendum The purpose of referendum is not to legislate. In the result, if the bill is not approved, then that is the end of the matter. Even if some parts are approved and others are not, the bill fails. Like a constitutional bill in Parliament, a bill by popular initiative cannot be amended or approved in part. There's no provision for that. And therefore, by stating that separate questions should have been placed for separate issues on such a bill, the court was actually acting contrary to the very express provisions of the Constitution. And it doesn't matter on whether
Mr. Oraro,
yes.
You said that the court pegged its decision on that point on which article?
Article 257.10.
10.
Yes.
Now, if you look at sub-article 10,
yes.
What does it say? And I think this is where the judges are coming from.
Let's look at it, my lord. 257.10
yes.
says as follows. If either House of Parliament fail to pass the bill, or the bill relates to a matter specified in 255.1, the proposed amendment shall be submitted to the people in a referendum.
The proposed amendment.
Yeah.
Not amendments.
My lord, but amendment, whether it is an amendment or amendment, it has by 257.3 to be formulated into a draft bill. So it comes as a bill, whether it is one amendment or many amendments.
And the question is, sir, at article, and that's what the judges I think seem to be saying, that under article 10,
yes,
it is the one question, it is the amendment that will be formulated as a bill and presented to the people. So I think the question that I would assist me at least to understand, why would the Constitution say amendment and not either amendment or amendments?
My lord, if we read it in context, we start with 3, which says that if a popular initiative in the form of a general suggestion, the promoters of popular initiative shall formulate it into a draft bill. So what goes to Parliament is a draft bill, not amendment.
If you go to sub-article 1,
yes,
you in fact will give even a better context.
Yes.
Sub-article 1 starts with what? It says
Sub-article 1 starts with an amendment to this Constitution,
yes,
may be proposed by popular initiative signed by at least 1 million registered voters.
So we have in sub-article 1 an amendment, yes, in between this process through a bill,
yes.
Then at 10 we still have the same singular, the proposed amendment. So please educate me there.
No, if it is reduced and the Parliament does not consider it in the context of each amendment as a separate bill, it is considered as a bill, whether it is an initiative by Parliament or by popular initiative. And it is that bill which is then submitted for a referendum, and that bill is an amendment as contained in the bill. That's my understanding of it, my lord. Yes. So in my humble view, it does not intend to have the question presented as different questions for each issue. No, I've taken too much time and I've eaten into my learned friend's time. I had an issue to address, but I'll skip it. So I will hand over to my learned friend to come out. Thank you, Lord.